10 seconds, 5 seconds, start. In substance, it was urged that the stated sales were in the course of import and could not be subjected to levy of sales tax by the state under the state legislation. Per contra, the respondents would urge that the authorities had constituted all aspects of the matter and, after due evaluation of the evidence before it, justly concluded that the stated sales were neither in the course of import nor export and had taken place on the land mass of the state of West Bengal and thus amenable to sales tax under the 1954 Act and the 1944 Act, as the case may be. It was urged that it is an admitted position that the goods were kept in bonded warehouses on the land mass of the state of West Bengal and were sold on the master of a foreign going ship as ship stores thereat. It was urged that the expression crossing the customs frontiers of India has already been defined in the CST Act and limits its application to area of a customs station as defined in the Customs Act to mean any customs port, customs airport or land customs station. In other words, the expression crossing the customs frontiers of India is exhaustive and would not include the bounded warehouses where the stated goods were kept to be sold to the master of a foreign going ship as ship stores. It was urged that being a taxation statute, strict interpretations should be offered to this definition as expounded earlier. It was further urged that the stated sales of goods by no stretch of imagination can qualify the expression in the course of import of goods into the territory of India, as is contended by the appellants, for that the goods must actually be imported into the territory of India and sale must be a single sale, which itself causes the importer or is in the process or process of import. It was urged that the authorities had rightly opened that there was sale within the state of West Bengal, whilst rejecting the claim of the appellant that merely because buyer had no right to consume the goods in question before the ship had crossed the territorial waters of India, that would make no difference because the sale was complete by the appropriation of the goods in the bonded warehouse itself. Similarly, the fact that custom duty was not paid on the stated goods would be of no consequence. It was urged that the appellants have for the first time raised a new plea that they had filed declaration. No such plea was taken before the concerned authority, nor any document or evidence was produced in support thereof for the relevant assessment period. The appellants therefore cannot be permitted to pursue this contention. Thus, the appeals be confined to the plea taken before the authorities below that the stated sales were not affected within the territory of the state of West Bengal or in India.